Technical team, we have people waiting. Are we letting them in?
Dr. Collier, we're live. We're ready to go.
Good evening, everyone, and welcome to tonight's webinar. I welcome you to tonight's webinar, Evictions, Understanding the Law, Your Rights, and the Eviction Process. This presentation or this webinar tonight is being presented by our Clayton County Public Schools Social Again, this presentation tonight is being presented by our Clayton County Public Schools Social Work Department. I'd like to acknowledge the co-chairs of our housing procurement team, Ms. Amanda Moore and Ms. Kimberly Daverson. We would like to thank them for their energy and their ability to pull together this important webinar that supports the housing stability of our students and their families in Clayton County. Tonight's webinar is in collaboration with the Atlanta Legal Aid and the Clayton County Magistrate Court. We'd like to thank our Superintendent of Schools, Dr. Morsis J. Beasley, for developing this collaborative relationship with our partners in the courts so that we can present this important information to our stakeholders as we work to ensure that our students remain in stable, healthy environments. I'm Dr. Angela Harrison Collier, Director of Student Services. And joining me tonight on the panel are representatives from the Atlanta Legal Aid and our Magistrate Court. So it is my pleasure at this time to introduce our panel that will be addressing those questions that you have submitted to us. And if time permits, we will attempt to address questions that have been placed in our chat. In addition to, we will, if we're unable to answer all of the questions, a Q&A will be developed and shared with our stakeholders at a later date. Our first panelist, Erin Willoughby, is a 2004 graduate of Appalachian State University and a 2008 graduate a Washington and Lee University School of Law. She began her public interest legal career just out of law school, becoming a legal assistant with the Atlanta Legal Aid Society. Through the intervening years, Erin has remained at Legal Aid, first as a staff attorney and later as a director of Clayton Housing Legal Resources Center. In her spare time, she enjoys gardening and spending time with her dog, Eddie, and her 3 beloved cats. Welcome, Ms. Willoughby, to the panel tonight.
Good evening, everyone.
Our next panelist is Chief Judge Keisha Wright Hill. And Ms. Willoughby, you'll have to forgive us if we show strong affection at this time for Judge Wright Hill, because she is a proud graduate of Clayton County Public Schools, having attended Lovejoy High School and graduated in 1994. She also graduated from the prestigious Spelman College in 1998, located in downtown Atlanta. She received a Bachelor's of Arts in Psychology. She received her Juris Doctorate from North Carolina Central University School of Law, located in Durham, North Carolina in 2002. Prior to taking the bench, Judge Wright Hill owned and managed a private law practice in Jonesboro, where she specialized in family law for 18 years. On June 9, 2020, Judge Wright Hill won her first judicial election and was elected as Chief Magistrate Judge by the citizens of Clayton County. She is only the 3rd African American in the county over the past 163 years to hold that seat. That is Clayton County Black history. I'll take the privilege to say that. Judge Wright Hill is very active in the Clayton County community. Her primary goal as Chief Magistrate Judge is to ensure that the magistrate courts is running effectively and fairly as possible. She works hard to educate and inform the youth as well as the citizens of Clayton County as a whole about the legal process that takes place in the magistrate court. Chief Judge Wright Hill enjoys traveling the country as a motivational speaker, encouraging, educating, and inspiring children, teens, and adults from diverse backgrounds. Welcome, Madam Judge. Thank you both for being here on tonight. We're excited about the conversation. Questions, again, have been pre-submitted, and we will do our best to answer as many questions as we can, if it is possible, during our live broadcast on tonight. We also have interpreting services that are being provided in Spanish. So we thank all of you again for joining us. We're excited to have you with us on this evening. And at this time, I am going to turn it over to our distinguished panel, Ms. Willoughby and Judge Keisha Wright Hill.
Thank you very much. We do have quite a few questions that have been pre-submitted, and we do want to address those expeditiously. I think we'll start. Before we start, I do have representatives from African Children's Fund, Ms. Diane Holly, who works very hard as far as dispersing the funds with the Magistrate Court. As well, we also have Ms. Joy Nobles, who also is a Spelman student, but she works quite a few hours in the Magistrate Court, and she assists the Magistrate Court as well as the African Children's Fund as far as processing the application. So I did want to address them and acknowledge them. And Diane, we'll start with you.
Hello, everyone. I do want to start off with giving the information out for getting in touch with the applicants. To complete an application or get a status up on your application. And I do want to give out our call center number, which is 770-347-0212. We do have a question. Our first question, what do I do if I have applied for rental assistance but have not received funds? We have a overload of tenants applying for assistance, and we're getting to them as fast as we can. We won't overlook anyone. We're working as diligent, and we do have a partner for Georgia Rental Assistance for DCA that you can apply to also. They're our partners with rental assistance, and you can apply for that. But we are working hard overtime and daily on getting to everyone. So if you could just follow up with that number that I gave, we'll give your status, and we're okay with just calling the call center on as much as you can to follow up on your status, and we'll give you a status.
Our next question, why doesn't Clayton County residents receive as much rental assistance as other counties? Well, I can't speak about the other 158 counties in Georgia, but I can speak on the greatest county in Georgia, that's Clayton County. And I can tell you what we have done and what we have received. Since March 2021, we have dispersed $1 million in county funds that we received from the Board of Commissioners. In addition to that $1 million, we have we have dispersed over $5.3 million in federal funds as far as rental assistance to assist the citizens of Clayton County. So that's over $6.3 million that we have dispersed in less than 1 year. We do have additional monies, federal monies that we are dispersing. So we send out, or I guess disperse checks twice a week. We've been doing this again since March of last year. Every Monday and Wednesday at the courthouse, African Children's Fund is dispersing checks directly to the landlords as far as back rent that's owed on behalf of the citizens of Clayton County. And we average, I believe, about $125,000 per week. So I just want to be clear, there is funding. Clayton County does have funding. We have federal funding. We're getting more funding, and hopefully this forum will assist our residents to be able to know the process, to be able to complete their application completely and fully so that we can get those funds dispersed as quickly as possible. Erin?
Hey, Madam Judge, if we could, in the chat, we've asked to repeat that number again from the African Children Network. The number that you provided that individuals can reach out to you. So if you could, please repeat that number again very slowly. I do want to let our stakeholders know that this session is being recorded too as well, and will be made available to you on our YouTube channel as well as on channel 24. So if you would please restate that phone number again very slowly.
Yes, it's 770-347-0212.
Thank you. Erin, if you could take the next set of questions.
Certainly, I'm happy to do that. The next question that we received is taping an eviction notice to the door illegal? The short answer is no, it's not illegal. In fact, it is the most common way that evictions are served in Clayton County. Is a process called tack and mail service. And that means that the sheriff comes and they tack one copy or tape one copy of the eviction court paperwork to your front door. And then the same day, they send a second copy in the mail. So if you receive an eviction notice on your door that says in the Magistrate Court of Clayton County, that is legal service of legal process, and you need to either, if you're going to answer the eviction, you need to answer the eviction within 7 days of receiving that notice.
Thank
The
you.
next question, can landlords withhold repairs until the rent is paid? And again, the short answer to this question is going to be no. In Georgia, a landlord's duty to make repairs is not in any way linked to the tenant's responsibility to pay rent. And what that means is that a landlord is obligated to make necessary repairs to the property, even if the rent is not paid. But on the flip side, a tenant is obligated to pay the rent, even if those repairs are not made.
Thank you.
I'm sorry. What do I do if my landlord refuses to accept the rent? Is the next question that I have on my list. First and foremost, you should save that rent. Do not, under any circumstances, spend it. If your landlord refuses your rent, it's most likely because they're getting ready to file an eviction against you. And the most common reason that evictions are filed in Clayton County is for non-payment of rent or alleged non-payment of rent, meaning the landlord claims that you didn't pay the rent. Whether or not that's actually true is something that remains to be determined by the judge. If you're served with an eviction for non-payment of rent and you have the rent available and can prove that you offered to pay it on time, you're in a much stronger legal position once that eviction comes up for a hearing. You should document the landlord's refusal to accept the rent by sending an email, sending a text message, sending a letter, something in writing, documenting and explaining that you tried to pay the rent, but it was refused, and offering to pay it on time. Keep that correspondence for your records because you will need it. Also, keep any correspondence from the landlord indicating that refusal to accept the rent. If you pay with money order and your money order is returned, make sure you make a copy of that complete filled out money order before you go and cash it back in, so you can prove that you tried to pay that money to the landlord.
Excellent. Next.
The next question I have is, what can I do to avoid having an eviction on my record? The only way to avoid having an eviction on your record, having that public record out there of an eviction filing, is to not have the eviction filed against you in the first place. In order to do that, you want to look at your lease first and foremost, so you know when is your rent considered late. It's not always going to be due on the 1st, late on the 5th. There's no requirement for a grace period in Georgia. I've seen leases that say the rent is late on the 2nd. I've seen leases that say the rent is late on the 3rd. I've seen them say the rent is late on the 5th. So know when your rent is due and when it is late, and pay on time. If your lease has rules and regulations in it, make sure you read them carefully and understand them, and do not violate them, because a violation of the lease is another reason that evictions get filed. If your lease is expiring, talk to your landlord about renewal before that renewal deadline. And if your landlord refuses to renew your lease, or you don't want to renew your lease, make sure you move out by the lease expiration date. And that way you avoid having an eviction filed against you for what's called holding over.
And let me just say right here, Erin, I do want to make note that I am working with our local delegation to help try to create legislation that would limit some of the information that's being reported on the tenant's rental history, as far as what type of eviction is being reported and who has access to it. I link it similarly to when you apply for employment. Oftentimes on the application, sometimes you may see a question that says, have you ever been arrested? Other times you may see a question that says, have you ever been convicted of a felony? So there may be situations where you could say no to have you ever been convicted of a felony, but the question, have you ever been arrested, you would have to say yes. Similarly, I would like to have some legislation passed where we could kind of differentiate between an eviction that is filed and an actual set out. And why I say that is because all of the tenants that we are assisting through our program, in essence, we are dismissing the eviction because we're able to use county and federal funding to pay the arrears. So was an eviction filed? The answer is yes. But was the tenant actually set out? The answer would be no, because we were able to use these funds to pay the arrears and the eviction was eventually dismissed. And so I believe that legislation should be put in place to differentiate between evictions that were filed and were paid off either by the tenant or by some type of funding versus an actual set out. And so I just want to make note that we are working diligently to try to get that type of legislation passed.
And I do want to acknowledge, Judge, we do have just since you mentioned that, State Representative Rhonda Burno has joined us this evening, and we do want to recognize her and thank her for joining the conversation. Hopefully we'll be able to provide her with an opportunity to speak at some point.
Absolutely. Whenever she's available to speak, we can do that. Before we go to the next question, Aaron, can you give the information on legal aid?
Absolutely, I'm happy to do that. The Atlanta Legal Aid Society is a nonprofit law firm that practices in areas having to do with basic needs. We do a lot of housing, a lot of landlord-tenant, we do a variety of other legal issues as well, ranging from unemployment to special education to food stamps, other public benefits such as Social Security and supplemental security. We also handle family law cases where there's domestic violence. So a variety of different legal issues, all having to do with people's basic needs. If you're a Clayton County resident and you have a housing issue, a landlord-tenant issue, you can call us Monday through Friday. You can call us from 9 to 5, and the number is 404-669-0233. If you're a resident of South Fulton County, or if you have a legal issue other than landlord-tenant, you can call us on a Monday, Tuesday, or Thursday from 9 to 11 a.m. at that same number. You can also visit our website at atlantalegalaid.org and complete an online application for assistance. And there's no charge for our services.
Thank you, Aaron. We go to the next question?
Sure. The next question is for me as well. It says, can my boyfriend evict me even though he's not my landlord? We live together and I pay my share of the bills, but he pays the mortgage. If the boyfriend in this situation owns the house, then he is the landlord, regardless of the nature of your personal relationship. If you do not have a written lease agreement, then that owner can give you 60 days notice that they want you to move out. And at the end of that 60 days, they could file an eviction for holding over. If both people are on the mortgage, then he's not your landlord. And in that case, you would have a defense to the eviction to say, this person is not my landlord, I own half of this house. Similarly, if it's a rented property and you're both on the lease, then that boyfriend is not your landlord, you are co-tenants. In a situation where it's a rented property, you have a lease, the boyfriend's name is on the lease and your name is not, then you can assert as a defense in the eviction, you can say he's not my landlord, but it's not entirely clear under the law whether the judge is going to consider him your landlord for the purposes of that eviction or not. So there's a little bit of a gray area in the law when you're talking about a sublease situation. But if the boyfriend owns the house, regardless of the nature of your personal relationship, he is your landlord and he has the right to give you 60 days notice to move out with or without a valid reason.
Thank you. Joy, can you take the next question?
I do apologize. I'm not able to see it, so I'm not sure.
I'll read it to you. I applied for rental assistance and my landlord that I linked my account to sold the property to a new management company. How do I switch over the landlord in Neighborly?
That's a great question. So it's not something that a tenant can do themselves. The best suggestion would be to call our ERAP call center with the number that Diane has given out. And it's a simple request. It's an easy switch of a button and we can just change a number and email out very easily.
Thank you. Aaron, next question.
Sure. My next question is, what is a tenant to do if the landlord is behind on the mortgage and loses the home in a foreclosure? And the answer is tenants are protected from eviction when a home is lost to foreclosure. Generally, the new owner must either let you remain for the term of your lease or give you 90 days notice that you have to move out, whichever period of time is longer. If and only if the new owner plans to use that property as their primary residence, then they can terminate an existing lease, but they still have to give you that 90 days notice. So you still get a bit of a runway, a landing stretch to try and find something new before they can simply file an eviction against you. And if they do file an eviction during that time, or if they do try to terminate your lease and file an eviction on that basis, you would have a defense to that eviction.
Thank you. Next question.
Is there an established amount of rent that a landlord can increase every year? No, there is not. Georgia does not have any rent control statutes, so landlords are free to raise the rent there's no government oversight of that process.
And I'll just add that that has been an issue that's come up recently. I just saw a story on it on the news on yesterday, and I have addressed it with our Board of Commissioners, and hopefully we'll be working on some solutions as relates to rent control. But thank you on that. And your next question, Erin?
Sure. My next question is, as a renter, should I come to court with an attorney if the landlord is represented by one? And if so, are there any organizations that assist low to no income individuals with this matter? It's almost always going to be helpful to have an attorney in an eviction, or at a minimum to get some advice from an attorney before representing yourself. As I mentioned previously, low income residents of Clayton County are eligible for free services, including legal advice, and in some cases, legal representation by the Atlanta Legal Aid Society. And again, the number to call for us is 404-669-0233, or visit www.atlantalegalaid.org. And I would add that the sooner you call us in the eviction process, the more likely we are to be able to assist you or give you some advice that might be able to help you avoid that court process. So call us as soon as you realize there's a problem. Don't wait until the day before your hearing.
Okay, excellent. And your next question.
What department do we need to contact to get judgments that have been satisfied removed off of our record? Once a judgment is satisfied, meaning it's been paid off, it's up to the landlord to contact the clerk and mark the judgment satisfied. And there's a form that they fill out to do that. It's a one-page form. Under the law, they have 30 days from the date you satisfy that judgment to do so. And if they do not do so within 60 days, then you have legal right to sue that landlord for up to $500 per offense plus attorney's fees if you use an attorney. The law presumes the damages to be $100 per occurrence. So if you have damages of greater than $100, meaning it has cost you more than $100 to deal with this judgment, then you'll need to be prepared to show proof. So you're going to want to keep declined housing applications, proof of application fees, any money that you have spent as a result of the landlord failing to mark that judgment satisfied. You're going to need to keep that documentation if you intend to sue the landlord for the violation.
Excellent, thank you. Next question is for me. We have a signed writ of possession, yet the marshals refused to execute the eviction because the case was placed on hold. Why are cases being placed on hold? This is relating to tenants who have pending rental assistance applications. So if there is a tenant that has one, we are putting the set out on hold. Now, if the tenant is not cooperative, is not responsive, is not communicating with African Children's Fund, and as far as having their application being reviewed and processed and approved, then we would proceed with the setup. But that would be the only reason why they will be put on hold. Do signed writs of possession expire in Clayton County if they're not executed within a certain time frame? No. That's been an issue that's come up with the Sheriff's Department, because during the pandemic, they did stop as far as executing the writs, and that was due to the pandemic. But as far as they would request new writs being signed, and that's not necessary. The initial writ is sufficient. Is there anything Clayton County can do to expedite the distribution of rental assistance funds? We have added additional staff. We have opened up our call center. We are dispersing checks, like I said earlier, twice a week. And just so the citizens of Clayton County know that dispossessories is a top priority for Magistrate Court. We do handle over 10 different types of cases in this court, but dispossessories is at the top of the list, one of our top priorities. And so we are doing everything that we can as far as adding additional staff, and trying to focus much of our time and efforts on the application process, making sure that the applications are being reviewed expeditiously, as well as the funds being dispersed quickly. What is Clayton County doing to expedite eviction hearings? And I know this has been a question that comes up often. I know a lot of landlords are like, when are we going to have the hearings? And I think the best analogy I can give you is this, that a riding lawnmower and a push lawnmower do the same thing. They cut grass. But a riding lawnmower is going to cut more grass in a quicker amount of time, in a short amount of time. And so the analogy of that is this. Prior to the pandemic, we were hearing, as far as dispossessory hearings, we had calendars in the morning and in the afternoon. The calendars in the morning and the afternoon, we had between 100 to 150 cases, which means we were hearing between 200 and 300 dispossessory cases a week. That was pre-COVID, when the courtrooms were full, when the halls were full, when there was standing room only in the courtrooms. Clearly, due to the pandemic, we had to change the way we operated. And so we've had to move to a Zoom platform. And so with that being said, our Zoom calendars, we have a 30, we can hear on the calendar in the morning and 30 in the afternoon on one calendar, that's 60. And then I have another calendar that hears another 10 to 15. So we're hearing about 70 to 75 cases per week, when before we were hearing between 200 to 300. And let me just say that as far as Clayton County is concerned, a lot of people may not know, there are 159 counties in the state of Georgia. The Clayton County Magistrate Court is the 4th busiest magistrate court, meaning we have very high volume. We have an enormous number of cases. And so when you combine the fact that we have a high volume with the fact that we have went through and are still going through a pandemic, it has slowed things down, not because we wanted it to, but that's just what has taken place. And we've had to, due to social distancing and making sure that we have the COVID protocols in place, we have had to change the way that we operate. I will tell you that the question has come up to me, well, what's the average time for a scheduled hearing? That's a hard question, but I will tell you this, that we hear the cases, the oldest first, and then on to the newest. So if you file an eviction today, pre-COVID, your hearing would have been in about 10 days. That's not the case now because of what I've just explained. And so I spoke with my clerk today, and we have hearings they're scheduling hearings now, they're in March, but we're just on cases that were filed in September. And so, and again, we're working very hard. It's just we have a very large number of cases. So please just pack your patience with you as we're trying to work through this. But if people are calling our office saying, I filed an eviction in January, when is my hearing? Well, we have to get to the ones that were filed in September, and then October, and then November, and then December, and then January. So again, it's been a process. It's been challenging, to say the least, but we are working as diligently as we can to make sure that we're not only dispersing the funds as quickly as possible, but also where it's needed and where it's requested that we are having the hearings as quickly as possible. Erin, can you address the next question, please?
Sure. The next question that I have is, I was told today by my landlord that even if I don't receive a court notice for eviction on my door, my property can still be evicted from the apartment. She says it's because it shows up in the magistrate court first. Is this true? The short answer is no, that's not true. Your landlord is not under any circumstances allowed to unilaterally set your things out of your property. They must have a court order to do so. To get a court order, they must go through the judicial eviction process. And for that process to move forward, you have to be served with those eviction papers, either personally when the sheriff puts them in your hand, or by tack and mail when they stick it on the front door and mail a copy to you.
Thank you. Next question.
What should I do if the landlord refuses to do work on the unit in some apartments? If the landlord refuses to make necessary repairs to your unit, you need to first notify the landlord in writing about all the repairs that need to be made. If they don't make those repairs in a reasonable amount of time, then you can notify the landlord of your intent to make the repairs yourself and deduct the cost of repairs from your rent. It is important, though, if you're going to do this, if you make the repairs yourself, remember, you can only deduct the cost of materials. If you physically make the repairs yourself, you can only deduct the cost of the materials you purchased. If you hire someone to make those repairs, though, you can deduct the full cost of the repair, including labor. So you deduct the cost, so you make the repairs yourself. And then when it's time to pay your rent, you pay the difference between the repairs that you made and what your actual rent is. And then you submit copies of your receipts to the landlord to show the difference. It is extremely important. I cannot overstate the importance of keeping those receipts and keeping that paper trail, because what is most likely going to happen if you choose this remedy is your landlord is going to refuse to accept the rent. They're going to call it a partial payment and say, we don't accept partial payments. And then they're going to file an eviction against you. And you need to have your proof that you notified the landlord of the repair, that they didn't make the repair, and how much you spent making the repair yourself, so that you can defend against that eviction when it comes. You can also call your local code enforcement and make a complaint to code enforcement. Similarly, if the landlord is not making repairs to other units, so let's say you live in a complex and there's trash that's not being picked up all the time, or there are vacant units that are causing problems, squatters, things of that nature, you can also call code enforcement for those problems.
Excellent. Thank you. Next question.
What is the process of not paying rent due to poor living conditions in the apartment? In Georgia, there is no process for not paying rent due to poor living conditions. As I mentioned previously, in Georgia, the law considers the tenant's obligation to pay rent to be completely separate and independent of the landlord's obligation to make necessary repairs. You can use the repair and deduct remedy, although it is risky. And if the unit is uninhabitable, meaning you cannot stand to live there, and usually you need code enforcement or the fire department to back you up in saying that. So the unit needs to either be condemned, or the fire department needs to say it's unsafe. The gas company may say it's unsafe. You need some proof that there's danger to your health and safety in living there. Then you can leave and sue the landlord for what's called constructive eviction. But you must actually vacate the unit for this to work. And again, you should carefully document the condition of the unit and your attempts to get the landlord to make those repairs before you move out of the property, because once you're gone from the property, all your evidence is gone.
Thank you. I'm going to pivot now, and what I'm going to do is I would like Joy to just briefly address some issues that you see during the application process, some things that may slow down the process, and what's important that the tenants know and landlords know when they're completing the application process. And after we hear from Joy, then we'll hear from Representative Pernod. I'm speaking into existence, I guess.
Oh,
Go ahead, Joy.
of course. So detail. The most important thing that you can do when you fill out this application is to fill out every space. If it's there for you to fill it out. A lot of times we have tenants who may leave off their landlord's emails, their phone number, their late notices, their COVID reasons. If you ever get an email from me, that means something is wrong. You don't want to get an email from me. If you ever get a phone call from me, once again, something is wrong. So if you are to fill out an application incorrectly, unfortunately, we may begin to look at a case over yours that has all their information correct. So once again, every single space filled out. If you have something that has caused you to be affected by COVID, you need to write it out in detail with a supporting document. As we have the ladies with Clayton County Public Schools here, mostly anybody who's a parent of a child in Clayton County Public Schools is eligible due to COVID reasons. But if you don't put it, we won't know it. So just details is all. Thank you.
Thank you. And Representative Brunel.
Thank you. This is really excellent. I am so proud of Clayton County's social workers and Dr. Collier, and of course, the magistrate, Keisha Wright Hill. And also I know that Aaron, with the legal aid, worked a lot to help us to make sure that we secured our unemployment claims here in Clayton County. So I just want to congratulate you all and let you know that you all are doing an amazing job to help the residents in Clayton County. I know that it's very frustrating and sometimes they don't understand the whole process. But after listening here, I think you all are really going out of your way to keep everybody informed. And I think that Clayton County is doing an outstanding job. So thank you all for your service.
Thank you, Representative Brunel. Did you want to speak any on the legislation that we're working on?
Yes, on that legislation, it is sponsored. I am the top sponsor, and then Representative William Bodie is the second sponsor. And so I was talking to him today, and we've made a few additions. So once we file the legislation, we will need you all to help to, get us a hearing with the chairman, Chuck Efstration, so that we can get the legislation moving. We are at the end of our session period, and so if we don't get it passed now, it won't go forward until we'd have to refile it again next year. So we will be asking you all to send letters and asking him for a hearing, because this is an important issue across the state of Georgia. Thank you.
Thank you very much.
And I'll have the bill number then too.
Thank you. Thank you for all your work that you do for Clayton County citizens. Diane, you have the next question?
Yes. I got approved for assistance by Hearts and North Shore in November 2021. Now they say they have run out of funds. What should I do? Actually, we have, that's the DCA, the Georgia Rental Assistance.ga.gov. They will assist. That's Georgia Rental Assistance.ga.gov.
Thank you. And I think I've already answered my question. Aaron, can we go to the next question?
Sure. The next question is, if a person has signed a lease agreement for rental property and the lease agreement only had the dates of the lease and for the person to sign the lease, but no actual terms and conditions, is the tenant responsible for any maintenance of the property? Regardless of the terms of your lease, even if you have a lease that affirmatively says you, the tenant, have to make all of the repairs, a tenant in Georgia is never responsible for maintenance. It is one of the landlord's what are called non-delegable duties, meaning they cannot force this responsibility onto the tenant. So you as the tenant should never be responsible for fixing things in your unit.
Thank you.
I also have the next question. Can an apartment complex file for eviction if they refuse to fix anything in the apartment you live in and you withhold rent because of their failure to fix anything? Yes, they can, and they will win that eviction. You may have a counterclaim for the reduced rental value of the property due to the conditions or for the costs that you sunk into trying to make the repairs yourself, but it will almost never be worth more than the rent that is owed. And if the judge in your eviction hearing finds that you owe even $1 of rent, then you will be evicted.
Thank you. Next question.
Can a landlord change the locks and remove the property from my home? Not without a writ of possession issued by a judge and executed by the sheriff. The landlord is only allowed to come into your home or send employees into your home when the sheriff comes to execute the writ. They are never allowed to unilaterally set you or your belongings out or change the locks or shut off utilities or turn off your gate card. They're never allowed to do any of those things without the assistance of the sheriff and a writ of possession.
Thank you.
The next question. My landlord verbally told me to vacate. Do I have to leave if we haven't gone to court yet? Absolutely not. There is one person and one person only who can tell you that your rental home is not your home anymore. And that person is the judge. If a judge has not told you that home is not your home anymore, it is still your home and you still have the right to live there.
Thank you. Once Georgia Emergency Rental Assistance Program paid my landlord over $6,000, the next week they sent me a letter stating my lease will not be renewed. This issue has come up since we started this program. And so we have put, I think, safeguards in place. What's happened, I believe, is that the landlord has received the monies. This may be a 2020 case. And they've received a check for $5,000, $10,000. And then the next month, the landlord files an eviction saying the lease is up, tenants holding over. So what we've tried to do as much as we can with the program is that now, if we see that there is a lease, well, we're in the middle of dispersing funds to the landlord, and we see that the lease is up, we will not disperse the check unless another lease has been presented to the landlord, to the tenant. It's the landlord's option. If they don't choose to renew, then that's fine. The case will be put on the calendar. But we're not, the purposes of these monies is to avoid eviction and homelessness. So it makes no sense to give all this money and then the same result happens the following month. So before we will give that check out, there has to be a signed lease by the landlord and the tenant. Not a promise, not I'm going to, not next week. They can sign it in the courthouse. Landlord, tenant will make copies, give them to both parties. As long as everyone does what they're supposed to do, we're in a good spot. But we will not hand out these monies and then the landlord turns around and tries to evict the tenant the next month because the lease is up. Okay. I think I've addressed that question. Diane, can you address 21?
Yes, I'm currently 4 months behind on rent. I started out a month behind, but the rental assistance took longer to process due to so many people applying. I was accepted and assigned to a program in January 2022. I found a couple of weeks ago the county funds are on hold. I received my eviction paperwork on January 7th and I answered it. I just need to know what should I do or what can I do if I was approved for assistance. My apartment complex doesn't accept partial payment arrangements anymore, so I'm honestly stuck. Actually, you can go to relief.claytoncounty.ga.gov and complete the application. And it's great that you answered to the eviction. But once we get your file, and in our office, we'll work your file. So go to relief.claytoncounty.ga.gov.
Thank you. And we touched on the next question a little bit, but Erin, if you could address it.
Sure. Next question is, how can my rent continue to rise each year without getting a raise or a better paying job? Every year since 2020, my rent has gone up $100 to $120, although I haven't received any more income. As Judge Wright Hill mentioned, For good or ill, there is no rent control in Georgia. And what that means is that landlords are free to raise and lower rents according to what they believe the market will support. A landlord, however, cannot change your rent during the term of your lease unless the lease itself gives them the right to do so. But once your lease expires, your landlord can demand a new rent amount to sign a new lease. And if you are month to month, then the landlord can increase your rent with reasonable notice.
Thank you. Can you take 24, please?
Sure. Within the eviction process, is there a time frame that the landlord must inform the tenant that they intend to sell the property? A landlord is not under any obligation to tell a tenant that they're selling the property. Not only do they not have to tell you in a certain amount of time, they don't have to tell you at all. This is because under most circumstances, the lease is going to survive that sale of the property, and the new owner will simply become the new landlord under the terms of your old lease. If you're in the middle of an eviction, though, and the property gets sold, and you find out that the property has been sold, then you should amend your answer to state that the plaintiff is no longer your landlord, as this may give you a defense to that eviction unless the new owner knows that the eviction is pending and intervenes to add themselves to that case.
Excellent, thank you. Diane, could you take 25, please?
Is there any help for any families that have already been evicted and that are presently living in an extended stay hotel? And yes, that you also go to Georgia Rental Assistance .ga.gov. They will assist.
Okay. And Aaron, 26?
Sure. My landlord filed for an eviction in September. We asked about repairs and no response. We waited for a court date and she filed another eviction in February. I am in no position to move immediately. What should I do? If you have an old eviction case that is still pending before the court, then you should state in your answer to the second eviction that there is a, quote, prior pending action. You should inform the court of the case number of the old eviction and ask that the second case be dismissed. And then you're going to want to go back to that old eviction and amend your answer with a counterclaim for the repairs and possibly retaliatory eviction as well, depending on the circumstances. So it's all going to be handled in the old pending eviction case. The new eviction case should have to be dismissed.
Yes, and let me just address that. Because it has taken some time to get to these cases, we're finding more and more multiple filings. I would say, as Aaron has said, the second one should be dismissed, but I still would say answer any dispossessory proceeding, because we've had the situation come up where the tenant answered the first eviction timely within 7 days. And then the landlord filed a second eviction and they were advised, well, you already answered, you're good. And then there was a writ signed. And so then the landlord tried to move on the writ. And so we have a whole, a lot of confusion. If there's one thing that I could say, if I could buy all the billboards on Terra Boulevard, I would say, answer your eviction within 7 days. Because when you don't, you have no standing to say anything. Think of your answer as the key that unlocks the door for you to walk into court to fight your case. But if you don't file an answer within 7 days, you don't have the key. And so your response to that, I filed, I have the receipts, the landlord didn't make the repairs, all of your defenses, I can't hear them because you didn't file an answer within 7 days. Every day I get stacks and stacks and stacks of files. And the only thing I'm looking at, I'm making sure that the name is correct. I'm looking at the date that the sheriff served the filing, and I'm adding 7 days to it. And then I'm looking to see if there is an answer. And if there is no answer, I am giving possession back to the landlord, period. That's it. So, and also this is a time when timeliness is important. 1 day makes a difference. Late is just like you have not filed an answer. So if you file on the 8th day, that's just like you filed no answer. And if you filed no answer, I have to what? Give possession back to the landlord. So if something's posted on your door, file it and don't wait till the last minute, because anything can happen. I was in the hospital. I had this, that, the other. But the only question that where we're looking for an answer is, did you file your answer within 7 days? I put it in the middle of the document. I've asked the clerk to put it in bold. People had an issue as far as, are we including weekends? Are we excluding weekends? I have put 7 days with 7 calendar days. Don't wait till the 7th day, because anything can happen. So if there's nothing else that you get from today, file your answer within 7 days and spread the word, so you have a fight in court, so that you can contact legal aid and contact Erin and have phenomenal representation to fight on your behalf. But she has nothing to say, because you'll never get into court if you don't file your answer within 7 days. We've addressed all of our pre-submitted questions. Before we go to any other questions, Erin, is there anything else that stand out to you that you would like to put out there that we haven't already addressed?
Sure. I'd just like to reinforce and echo what Judge Wright Hill just said, that it is 7 calendar days from the date you were served. It is not 7 business days. I cannot tell you the number of times I have talked to people who have said, I thought it was business days, so I counted business days. And I have to explain, I'm sorry you missed the boat. There's not anything we can do. It is 7 calendar days. If you get served on a Saturday, then your answer deadline is going to be 7 calendar days till the following Monday. If your answer deadline falls on a holiday, it's going to be the day after that holiday, but only if the answer deadline falls on that weekend or that holiday. You count those 7 calendar days if there's a weekend or a holiday in the middle.
Thank you. Dr. Collier?
Yes.
Madam Chief, I'm sorry, Dr. Collier, Madam Chief and Attorney Erin, we do have some additional questions that have been submitted. And out of respect for you all's time this evening, do you want to take some of them, or would you like for us to write them up and then we can post them later?
We have 5 minutes. Let's take 1 or 2 questions.
Yes, ma'am. Okay.
And if I can, Amanda, before you start, if I can just, for a broad stroke, of a lot of the questions are around funds and availability of funds and how to get support and assistance. So if someone could repeat that again, because that seemed to be a lot of questions, individuals facing eviction, needing funding, and how to access funds. So if we could get someone to answer those questions, and then if Ms. Moore and Ms. Davidson can also ask from the district's piece and our housing procurement team, if they are a Clayton County parent, what they might need to do too as well.
And I'll have Diane answer that. And I forgot, let me just say the process as far as what happens with this funding if there is a pending eviction. So an eviction has been filed. The tenant has filed their answer within 7 days. They have went to the website and applied for assistance. They have to complete the application. Now, the key word is fully in its entirety. I believe it's 7 steps, Joy. So when people say I applied, but it's 2 out of 12 steps completed, that's not complete. It needs to be 12 out of 12 steps completed. And then the tenant they'll receive a case ID number, a 5-digit case ID number. And you can call the call center, as Diane gave the number earlier, and say, this is my case ID number 12345. Can you give me the status of what my case is? It may be that Joy needs a document uploaded. It may be that she needs some additional information. But once we get everything that we need from the tenant, we contact the landlord and get all the information that they need. And then Diane and her staff negotiate a settlement amount. So it may be that you owe in totality $5,000, but they will negotiate. They'll try to get the late fees taken off, and they'll try to work down and come to a number that they can agree upon. So you owe $5,000, and we might be able to come to an agreement of $4,200 Okay, so then what happens is we're all on the same page. It's explained to the tenant and the landlord that the $5,000 is owed, $4,200 will settle the amount the arrears is owed by the tenant. And therefore, the landlord cannot come back after the tenant for the difference. They can't come ask them for the $800 difference. They can't come and sue them in small claims court for the $800 difference. They can't add $800 the next month to the rent. When the $4,200 is given to them, that's it. It gives the tenant a zero balance. It gives them a clean slate. And so then they will, Diane will schedule a time for the tenant and the landlord to come in on a Monday or Wednesday. The tenant will come in at 10 o'clock. We'll sign off on the documents to state what I just said, and that they understand that process. They also understand that we are paying through the month that we're in. So this is February. So if they come in tomorrow and get this check, we're taking care of February and going backwards. But starting March the 1st, the tenant and the landlord know and understand that the tenant is responsible for paying their rent on March the 1st. If the tenant does not do that, the landlord is within their right to file the eviction, another eviction for non-payment of rent. So once the tenant understands that, they sign off on that in the presence of a notary, stating that they understand that. The landlord comes in at 1 o'clock and signs the same settlement agreement. They sign an affidavit saying they know and understand exactly what it is that I stated, that they know and understand that they can't come back after the tenant for these monies. And so, and that if they do, that any action that they take will be dismissed, because we just told them they couldn't do it. They can't double dip and try to get funds here, funds there, because now we're talking about fraud. Now we're talking about criminal sanctions. So they understand all that. And we make sure that they sign all that in the presence of a notary. And then we file that in the court. And then once we have all those documents, the landlord has signed off on it. If a lease needs to be signed, they can do all that right there, because they're both at the courthouse at that time. After all of that is signed, both parties understand everything. We have a good lease if we need one. Then we will hand over a check and put it in the hand of the landlord. So at 1 o'clock, everyone is good. Then Diane will give the file to me. I will sign a dismissal of the eviction and dismiss the eviction. The end. That's how that works. But you're still responsible for your rent starting the next month. So I just wanted to explain the process. And so it's given, and it's very helpful in situations where a lot of people are back to work now and are able to pay their rent moving forward. They just have this arrearage over their head that they just can't get over. So we're clearing the slate. We're and cleaning that slate, and you don't have to worry about that and moving forward. For COVID related, it has to be COVID related reasons why you were unable to pay your rent. And so that's how the process works. Diane, if you could give that information.
Yes, we're an active eviction. You will go to relief.claytoncounty.ga.gov. And if you need assistance going forward and also pay back rent, you will go to georgiarentalassistance.ga.gov. And we do have the funding.
So the relief.clayton is if you have a filed eviction in the Clayton County Magistrate Court. And that means that the paper was put up on your door. You would have an eviction case number, which would begin with 2022 now, CM, and a 5-digit number. That means you have an eviction. Just because the landlord puts a piece of paper up on your door that says, we're going to file an eviction in 3 days, that does not mean one is filed. So if there's an actual eviction filed, you're going to go to the relief.clayton website. If an eviction has not been filed, but you are still behind and need assistance, that's when you go to the other website.
I would just add briefly a process tip for filling out those applications. They do ask for a fair amount of documentation. If you don't have something that the Neighborly app asks for, if you don't have a document, say you don't have a written lease, for example, because you never had a written lease with your landlord, at minimum, write out a statement explaining why you don't have that document and upload that. So the application doesn't get flagged as incomplete. Someone can look at it and see whether that's a valid reason not to have that documentation.
Excellent. Ms. Moore, did you have any questions?
I believe you wrapped it all up. It was one question that really did stick out where someone asked that if they've already received assistance, can they apply or request assistance for a second time?
Diane?
Once you apply again, if it has to be a second reasoning due to COVID. It can't be the same COVID statement that you put in for the first assistance. You have to have another COVID related situation. So if you have that, yes, you can.
Okay, and Diane, I just had a quick question. Is there a link that you can share with us so that we can try to get it out with the numbers and the link and just everything so that parents and families can make sure that they have what they need as far as getting the assistance they need?
Oh yes, I can provide that for you.
Okay, I believe that Dr. Collier, do you have anything that you would like to add?
Well, just before we jump off, just in general, is there a cap or when will funds run out? Is there a time frame? I think it's important for us to answer. And is there a cap on the amount of assistance that an individual can receive? Someone has that they need assistance that's over $6,000. Is there a cap on how much they can receive? And I think that that will really address a lot of the concerns that are out there in the questions that we have gotten.
We will assist up to 12 months back. So if it's 6,000 or 10,000, we will assist with 12 months arrears, up to 12 months arrears.
What about mortgages? Because that was another, not just rent, but mortgages.
With the mortgage, we would actually Georgia Rental Assistance.ga.gov assists with mortgages. They have a program within their program for mortgage. And I'm not sure how far they go back. Not at this time.
And so let me just reiterate, Clayton County does have funds and we're working on getting additional funds. Mm-hmm. We work hard and we are good stewards of the monies that we've received from both the county and on the federal level. And so because we don't just let the money sit, we take the money and we give it out to as many people as we can. And the county recognizes that and the federal government recognizes that. So when you're good stewards of the money, they find additional monies for you to continue to be good stewards of the money. So Clayton County does have money for those that have evictions. Clayton County does have money for those that are pre-eviction, and we will continue to disperse the funds, but we have money.
Wonderful. Thank you so much, Madam Chief, for that, as well as Attorney Aaron, Ms. Holly, and Ms. Nobles. We appreciate you, as well as State Representative Mrs. Bordeaux. Thank you so much for joining us this evening. It is a true pleasure to have you with us. As Dr. Collier stated, we do have a housing procurement team within Clayton County Public Schools, and we work with any referrals that we may receive from our colleagues, school social workers at the various schools that your children may or may not attend or may attend. You can send them or reach out to them, make contact with them regarding your situation, needing assistance with your rental, evictions, or any of that. They will have a form that they can assist you with completing, and then they will submit it to our team, the housing procurement team, via email. And once we receive those referrals, then we send them out to our various community partners. So we have been working diligently over the years prior to the pandemic to solidify and rack up any of the community partners that we can work with that potentially can assist our students and families within Clayton County. So with that being said, if you have any questions or any concerns about how to submit a referral for assistance with your rent or anything like that, please reach out to your individual school social workers and they will be able to complete the referral form and pass it along to the housing procurement team. I believe that is all that we have for this evening. We do thank you for joining this webinar. Please note any questions that we were unable to answer this evening, we will try to work with Madam Chief as well as Attorney Aaron to get them questions answered and find a way to share them with you all, because we do value your time to join us this evening and submit the questions to us. And then we understand it is a very serious and urgent matter for us to address for you. So thank you all. You have a wonderful evening.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.